live. I'm not seeing it on the actual channel. Let me see. Live. Maybe there's a delay. Ah, there we go. All right. Okay, just gotta mute this. Okay, we are live. Let's see.
Excellent.
Organize the chat here.
Jay, is it helpful for me to sign into the chat so I can see it, or should I just rely on? I don't want to cause too much, you know, noise. If
In the on the YouTube chat.
yeah,
Yeah, absolutely. Up to you if you'd like to be a part of it. It can get a bit much, but I'm just going to try and pull some questions as they come after we get through this. I would just make sure you mute it.
yeah,
That's all.
yeah. Hearing my the delay.
So we got a few people there. Catherine, hello. Woodcrafter in your pocket. Can't hear you. Really? Can't hear us? Carla Murphy says hello. Drop us a yes if you can hear us in the. Hey, Brian. It's not good if you can't hear us. Eric, oh, Jay's very quiet. All right. Is this better? I hope this is better. I turned up the gain on the mic. I hope that's better. Jay is really quiet. Okay. I can hear you. You can hear me. Okay. Jay's volume is low. How's this? Is this better now? Let me know. Type a 1 in the chat if you can hear me okay. A little better, but still quiet. Type a 1 if this is better now. I just turned it up all the way, and I know there's a delay. Well, that stinks.
Jay's just gonna have to shout into the microphone as loud as
Yeah,
he
I guess
can
so.
to compete with my booming voice.
Much better? Okay, that's better. Still quiet but audible. 1 1. All right, we're good. So you guys can hear me. So there is a decent delay there, but that's okay. Right on. Okay, good. Okay. What's up, folks? Well, I guess we'll get going. A pretty active chat already, which is great. So, thank you thank you all of you for joining. This has been something that we had. Eric was nice enough to grace us with his presence inside our Inner Circle membership. So to be able to have you on again here to YouTube Live, I think is just there's so much really good information and intel that we can glean. I think from a good conversation, similar to what we had inside the membership group there. So. Thank you so much, Eric. Without further ado, just please, I guess, give us a brief intro of who you are, and thanks again for doing this second round. I think it's just going to be a wealth of information for everybody.
Yeah, thanks, Jay. So my name is Eric Perrott. I'm in Washington. Excuse me. In Washington, D.C. I am a trademark and copyright attorney. This is the only area of law I've done my entire career. And so I absolutely love it. I think that I look at what some of my friends who went to law school are doing, and I am thankful every day that I get to wake up and work with people's brands and creative content and do a small part to help them. And so yeah, I've worked with about 10,000 or so brands to help them protect the brands, register it with the Patent and Trademark Office. I've filed, I think, about 1,000 copyright applications and then counseled clients with everything in between. And so I work with a lot of really big clients, but I also work with a lot of very smaller shops and creators and people who are kind of just looking to make things and to not get in legal issues with them. So yeah, excited to kind of talk to everyone today about the different pros and cons of different approaches to trademarks and copyrights, things to watch out for, and anything else that people have questions on. So looking forward to it.
Right on. Thank you so much again for doing this. I'm wondering if I, yeah, no. Sorry, folks, you're gonna have to deal with not so awesome audio, I guess. Um, but yeah, so the format for today, folks, is just gonna be Eric's gonna walk us through what he's got a bit of a presentation, I believe, and then we'll get into some Q&A. We've got a couple of questions I know that you guys are going to be interested about, especially with the election and everything, and people using, candidates' likenesses and what's that's kind of the biggest one I think on a lot of people's plates here. So we're gonna get going. I think if we're all good to go, and yeah, we'll get these questions in a little later.
Yeah, and I want to spend as little time on kind of the background as possible, just so we can get into the questions. But I think it's helpful just to have a framework of what we're talking about here. I think there's a lot of people are coming at it from different angles, so I think it's just helpful to at least give some general information. And I'll also make these available to everyone so that they can kind of follow along. It's got some good information. I'm not going to go over all of it that's in these slides, but you can take a look at them. It also has my contact information. I'll put it in the chat as well. It's Eric at gerbenlawfirm.com. And the first thing to kind of discuss is that this is not legal advice. This is super important, and I'm not just saying that because I'm a lawyer, but I am a lawyer. I am not your lawyer. At least, well, I guess Jay, I am your lawyer. So I will, except for Jay, I don't think anyone in the chat is officially engaged us. So, and the reason why that's important is not just to be a obtuse lawyer. It's because small facts can make an enormous difference in how to analyze a trademark or copyright matter. You might hear something that you might say, oh, that's exactly what my issue is. I'm glad he talked about that. But your thing might have a small fact that's different from what I'm talking about that could make it a completely different issue. So I'm gonna, just say that, and not even just to be kind of annoying, but and then the other part is, I will say this phrase a lot. It depends, and because with trademark law and copyright law, there are very few bright line rules that I will say, under no circumstances can you do this, or if you do this, you'll be perfectly fine, because what my job is more about is not kind of binary yes or no answers. It is about accepting risk. And so, and some people are very okay with a lot of risk. Some people are okay with, are not okay with risk, and they got to kind of navigate what's comfortable for them. And so, if you hear me say this, it'll become kind of almost a running. You'll think that I'm just messing with you sometimes by saying it, but no, it is actually very important because of that exact reason that I mentioned before. There's so much different, so many facts that go into these that you're going to hear this a lot because it is so fact specific. If you have questions about your particular issue, send me an email. I'll at least point you in the right direction and see if it's something that I can give you some recommendations on, and go from there. So that kind of said, what are we talking about today? And those, the focus that I'm going to have is on trademark and copyright law. And trademarks can be almost anything that represents your brand. So names, logos, it can be something even more extreme. I'll kind of give you examples of your product designs can be trademarks because they represent a company even without seeing a name or a logo. Slogans can be protected. In some cases, and this is what a lot of you might run into, it could even be something like yeah, names within fictional universes. Duff Beer from, oh, no sound. Jay, can you still hear me okay? So Jay, you're on mute, but I am not sure if people can hear me or not.
I can hear you, no problem.
Okay, well, I'm getting a, okay, so
I
never,
have
sorry
sound.
about
Hey,
that.
people have
Yeah,
sound. It
if
was
there
not
are
an issue.
issues, let me know. I'm getting a little bit of like distortion, but it could also just be my headset. So I want to make sure everyone can hear me, and I don't sound like I'm in a hardcore band or anything. But if so, let me know. I'll mess with stuff.
Does the
Um,
distortion go away when I mute?
no, I think it's just kind of the feedback in the in my headset, so that's not a problem. So,
Okay.
trademark's going to protect things that represent brands. And copyrights are going to protect original works, so things that are created and that can be very anything from a photograph to artwork, but then it can also be words, longer phrases, but there's a line there. So we'll kind of do a little bit of a discussion about where that line is, and the answer is going to be it depends. A final thing is patents. I don't go into patents a lot with this because they don't always apply, but just know that patents can protect the way that things are done in unique and novel ways. So typically machines, inventions, things like that, but there also can be situations where the design of something, the shape of it is so unique that it's never been done before that there's something called design patents. So if you're interested in that or if you've seen that happen, it's the most common thing that we see is when you start to do your reselling of generic items online. So the biggest one in the past has been like Apple, the AirPods. Apple has trade dress in that. They have design patents and have been able to be pretty successful in stopping people from mass selling lookalikes. And so just know that those are out there. We won't go into a ton of detail. But the big things we're going to talk about today are in the, especially in the print on demand industry, trademarks and copyrights. And so, words, phrases, anything that makes that connection. It doesn't have to be something that you know where it comes from, but when you see a phrase, you need to say, oh, that belongs to a business, a single business. And I encourage everyone here, you're going to be using trademarks, hopefully sparingly, but you might run into issues with trademarks that you're printing, but also really build your own brand. The best way to avoid potential confusion is by having such a strong brand yourself that when people are buying it, they're buying it because of the quality you provide, and they know that you have great designs, you've got great quality, not for just the content that you're providing. That can really go a long way towards um, you know, running into some of these issues for likelihood of confusion. And do people think it's an officially licensed product when they see your name kind of in a very prominent space when you're selling things and you have a name that's very distinct, that can go a long way towards avoiding problems. Quick, we'll do a lesson on identifying trademarks. This is the Under Armour website from a few years ago. You can see the symbol in the upper left-hand corner. It's the Under Armour symbol. It's Under Armour down at the bottom. It's that stylization. They have protection over all of it, and likely some of the other kind of designs that they have and product listings and things like that are going to also have trademark protection. Here's an Adidas box. These three stripes, Adidas is very, very aggressive about stopping anyone from using similar three stripes. I had a musical artist that had just three stripes in a logo he was using, and they reached out to him and said, no, you can't register that because he wanted to. And it was ridiculous, but just know that that kind of stuff is out there. These symbols can all be protected. And trade dress, the look and feel of something can be protected. This dripping wax on the maker's mark top, that is a protected trademark. If another liquor company did a dripping wax, presumably maker's mark would reach out to them and say, we own that as a registered trademark. And then the one I mentioned before, the Apple iPods or AirPods, they have protection that goes beyond just sticking Apple on it or do the Apple logo. It is the actual look and feel of that. When people hold those in their hand, they're going to know without ever seeing an Apple product or Apple logo that those belong to Apple. At least that's what Apple wants everyone to believe. And I think it's a pretty decent example. I think that there's a lot of third-party use of it, but I think it's mostly because of how good Apple did of making that so noticeable. When you're developing your own trademarks, and this will kind of go into also when you're trying to defend against other people's potentially questionable claims, there is a spectrum. On one side, trademark law does not want to give exclusive rights to any one person in a phrase that should be available for anyone to use to describe their product. And that is important because you shouldn't have to be able to monopolize very common words or phrases. And I think it's important for all of you to know that. The other side of the spectrum is made up words, words that have no meaning in the industry that you're working in. There's no reason someone should have to use those phrases to accurately sell their product. And so those are given very broad protection. And you want to be careful with those kind of phrases because they are given broad protection. There's no reason that they should be able to use them unless you're trying to sell that product. And then in that case, you have to be able to use it to sell that product. It's called nominative fair use. We'll talk about that later. But a lot of trademarks fit right in the middle, where it is might suggest something about your trademark. The example that I've always heard is Mr. Clean for cleaning supplies. Who is Mr. Clean? What is a Mr. Clean? Yeah, it's enough of it to identify that it has to do with cleaning supplies, but it doesn't really tell you much else. And so that's a pretty trademark that's distinctive, but it's not necessarily arbitrary. It's has something to do with a fictional character being called Mr. Clean. So yeah, finding where your trademarks, when you're developing your brand, fits in all of this is really important, because on one side, descriptive trademarks, well, they're not really trademarks, they're just descriptive words, and they're makes it really easy to sell your product. It's because it describes exactly what it is. On the other end, fanciful, arbitrary trademarks don't give you any helping hand when it comes to describing what it is. That's why you're given such broad protection, because any meaning in that phrase is what you or the brand owner have given it, and therefore they're going to protect that a lot more than they will a descriptive phrase. And then in between, it gets kind of in that sweet spot, less, not as much protection, but still protectable, and that's how this kind of spectrum works. And common misconceptions, yeah, everyone else is doing it isn't a legal defense. Yeah, ignorance of the law is not a legal defense, and every case is unique. So you're going to see, and one of our examples is going to be unfortunately, massive amount of what could be infringing works, and you're going to look at those and say, well, I see all of these other people doing it, and the rights owners aren't taking action. Can I do it as well? And the answer is, we can ring the bell. It depends, and it depends on how much risk you're willing to take, because it could just be that the rights owners have their hands full with so much that they just haven't gotten to it yet. And if you're basing your livelihood around using something that could potentially be legally questionable, then you know, that is going to be something that you're going to have to decide if it's worth joining everyone else within that pool of risk. And there's not kind of a clear answer for any one situation. You can kind of start to figure it out a little bit from case to case, but knowing the boundaries, at least where you can, is super important. And then know a good IP attorney. I think that even if you never have to use them, at least having that relationship in place helps avoid some issues. If you have to scramble, if your shop gets a takedown notice and you need to act quickly, having someone you already trust is good. It doesn't have to be me, but I highly recommend finding someone that you trust that would be able to address these issues on short notice. Your business attorneys will likely say they can handle these issues. I am a specialist. This is all I do. I don't do business formation. I don't do anything else other than trademarks and copyrights. And so I think there's a little bit of nuance that gets lost sometimes when a generalist goes and tries to get into some of these specialized areas, but I'm also biased because that's all I do. So just be aware that unless you're dealing with someone who does this full time as their only area of law, you might get different levels of advice, and just to make sure that you're aware of that.
That's a good point, because when you say just because everybody else is doing it, I switched my mic now, so I'm just using the MacBook mic. So hopefully it's a bit louder. But that is something we see all the time, especially on Etsy and Amazon, is everybody and their brother, sister, uncle doing, infringing on Disney trademarks all over the place. Even the form of the ears, right? Those are protected as well. But everybody is doing a ton of Disney stuff, and everybody keeps saying, "Well, there's 1,000 shops or 10,000 shops doing this stuff. How why is Disney allowing this?" So, and I guess you kind of alluded to it, but it's probably just because of the sheer volume of infringers that they're kind of prioritizing, I guess.
Yeah, it is. That's exactly right. And some platforms actually have relationships with IP owners. I think it was the Twilight franchise many years ago that had come up with at least licensing scheme with the owners of that said, well, if you just include the the names of the characters, or there was something in that where they did, so it was even just platform by platform might change what the rules are that platform will allow, but the default should always be this idea that that trademark owner just has not gotten around to it yet, that they're dealing with counterfeiters, like actual counterfeiters that are just saying, I am selling Disney stuff. And but yeah, it does happen, and I think that when you get caught in these wide nets of takedown notices, that's when it can become extremely painful, because a there's not a good incentive for a platform to continue to sell something that a large brand owner has said, well, I think this is infringing. Even if they're wrong, I think that the platform is still going to side with the brand owner most of the time. And there's not usually a clear counter notice procedure. And we'll talk a little bit more about what that is like. But yeah, I think that it is something that is about it. Sometimes it might be worth the risk, sometimes it's not, and it's just kind of what people are comfortable with.
Yeah.
And
Um, I
Jay,
would
I'll
just say,
save.
don't do
Oh,
it,
sorry, go
Eric.
ahead. Yeah, right.
I was just
Yeah,
gonna say, don't do it.
yeah, I think that is a good. I think anytime you're basing your livelihood on someone else's intellectual property, you have to have your red flags up and say, okay, I'm playing with fire right now. And if you can base it on your own original artwork and your own, characters that you make and your own kind of like quality, I think that's always the better way to go, because you're creating something for you. You're not piggybacking on someone else. But there's a lot of money to be made, and I recognize that as a pragmatist, that there's a lot of desire for these things. And yeah, I think that that's just a little bit of something that everyone has to decide personally what they're willing to accept. I've got a few more slides. I'm almost willing. We can talk a little bit about takedown notices. I might bring these up just in case someone's interested. Not sure, and in the chat, people can mention this if you've received a takedown notice before or have sent one, because what I mean by takedown notices is that there's a law called the Digital Millennia Copyright Act that says if you are a platform, a marketplace, you can escape copyright liability for your users if you have a system in place that takes down infringing content within X amount of time. And it is kind of ingrained into this idea that rights owners are responsible for policing their trademarks. The platforms themselves do not need to proactively skim through listings. Some apply algorithms like YouTube, but to try to catch things that might be infringing, just to avoid potential issues with rights owners. But it's up to the rights owners to enforce their rights. And so the way they do that is typically through what's called a takedown notice. Every website that you work with has a DMCA takedown notice procedure. Every single one of them will have that. It's just now a part of everyday life to avoid getting sued because someone put something that belonged to someone else. So there's counter notices. You can submit a counter notice saying, I think you're wrong or you're mistaken, and the other side has to process that within a certain amount of time as well. There's no guarantee that they have to relist it. And like I said, the real incentive for the platforms is this idea that they want to keep their users. So some might be a little bit more flexible. They might side with the user and say, well, all right, you've submitted a takedown notice, I'll let you relist it. Some don't. They say, yeah, we have a takedown notice that's going to be on your record, and if you get a bunch of these, we're going to shut you down. And that's something to be very aware of, especially on Amazon, that you can get shut down with very little due process. There's no court case that you get to go before a judge and say, hey, I don't think this should have gotten taken down. You can, but you have to do that proactively through a federal court. Amazon says, all right, yeah, you're shut down. There's an appeals process, but we
And
make no
that's
guarantees.
I think that's part of it, is like people get so frustrated with that, and Etsy is the same that way. But it's like you guys have to, I think, remember that they aren't willing to be involved in any convoluted legal issues, right? They just want to wipe their hands of it, so it's easier and faster for them to just boot you from the platform, and then put the ball in your court in terms of trying to protect yourself or get your account back, I guess, right?
Yeah, no, exactly right. And a lot of the times, what I end up doing is I'll get, a client will say, someone filed this, I need, help with this, and we'll reach out to the rights owner directly. I've dealt with, Warner Brothers with some of the Harry Potter stuff several years ago. I've dealt with a lot of different people, and when you have a lawyer on the other side, a lot of the times what's happening is that there's these services that will say we will detect, for X amount of dollars a month, and it's expensive. We will scour the internet looking for infringements, and then someone at the company can go and click go, and I basically files mass takedown notices. No attorney involved in the process. It's usually someone in-house at the company, and it causes complete chaos. And I had one of these happen just recently with a client that they got a bunch of these takedown notices, and it was like, guns blazing, reaching out. And the attorney was like, I am sorry, I told the client not to file and we had this kind of heart to heart of like why this is a terrible idea. But those exist, basically these blanket takedown notices that they're not paying attention. And I think that is a ton of liability when it comes to the people pressing go on that, but a lot of folks just don't have the time or money or knowledge to fight those kind of things. And I think that's where sometimes, even if you are 100% right, the other side is 100% wrong, unless you're willing to escalate things to the point where they feel like they're going to actually be held accountable. There's not a lot to do, and it's really frustrating, I think, for a lot of smaller businesses and large businesses too, that no one wants to spend money on legal fees. And so knowing that there is some mechanisms, unfortunately for trademark infringement, if you're using someone else's brand, if some platforms use the same schema, but there's no legal requirement under trademark law to have any kind of takedown notice for trademarks. Every platform should have some mechanism for it, but it's a lot less predictable compared to copyright law. So just kind of be aware that it's very platform specific there.
Okay, so meaning what? So like it's the platform can act on the trademark holder's behalf. Is that what you're saying?
Well, yeah, so that when a trademark owner submits a takedown notice, it's not subject to the same counter notice procedures in some cases that a copyright filing is. So
Right, we
they
see
might
that on
just say,
Etsy.
right, that they say, hey, trademark's different path, and it might be something that they give very little ability to appeal. They say brand owner complained, take it off. And unlike copyrights that have a counter notice procedure, there's nothing in the law that says in order to avoid trademark infringement claims, you have to do X, Y, and Z. There's no safe harbor like there is in copyright law, which creates a lot of really screwy things of, and from a lawyer's perspective, it gives us a lot of different opportunities for when someone is infringing. It gives us the ability to kind of approach it in different ways, but it's also very frustrating for folks that might be on the receiving end of that, especially if it's not someone who's filing in good faith. That can be something that is very painful and confusing, to be perfectly honest.
Oh yeah, it sucks. It sucks being the victim of the trademark bullies out there for sure.
And then there's the other one, and this is I think the last thing or there's one more slide, and then we'll get into questions. But this is a scheme that some of you may have been targeted by, and I say scheme because I don't think it is purely. I don't think it's purely malicious. I think this comes out of ignorance of the law more than anything else. Is this idea that I have a phrase that I think that I made up, or I was made popular in pop culture, but I want to try to monopolize it. I have been told short words and phrases are not copyrightable. That is true. A phrase like, I'm trying to not stick my foot in my mouth. I thought I saw one that is going to be a little controversial, but it says boy mom, and that being a phrase of a particular type of mom of boys, and that is something that is widely used in pop culture. And I think the better one is actually I just did a post on this, so I'll use this. It's safer. F around and find out. Yeah, I think you put that on the front of a T-shirt. Someone wants to try to monopolize that. They file with the Patent and Trademark Office, and they get an examining attorney that's not paying attention, and they're able to register it with the Patent and Trademark Office. There's some phrases that the examiners just don't know are pop culture phrases, and there is a number of those kind of things that come up that you do not, in my opinion, identify a business, but they put it on a tag, they put it on a hang tag, and likely worked with an attorney to say, well, yeah, this is my brand, but it's not actually a brand. It is a phrase on the front of a T-shirt, and that does not. We back to the beginning of the presentation. We said a trademark must identify a specific phrase or a specific company. It can't just be a phrase that people like to see. It has to identify where that product is coming from. But you can tell the Patent and Trademark Office whatever you want. If the examining attorney is sleeping, then they might let it through. Luckily, the F around and find out one was refused because they did the research and said, well, that's such a widely used phrase, no one should be able to own it. But some of these phrases do sneak through, and we see these all the time. In the chat, someone mentioned most likely to is pending. And there's certain circumstances where if you're doing most likely to for a brand of motor oil, like that's a kind of yeah, that's an arbitrary mark for a motor oil. But if
It
it's
would
a
almost make
phrase,
sense.
exactly, yeah, it doesn't
Yeah.
make any like most likely to what, like
Yeah.
it's a motor oil, or even like things like musical headphones or something like that that have nothing to do with. But if it is a phrase on the front of a T-shirt, that's all it is. That to me does not function as a trademark. But there's nuance to that. So what I have seen happened is that, and I'm trying to think if I can actually talk about this or not. It was a phrase from a movie that someone was able to register in connection with an apparel item, and they filed takedown notices. And the first thing I did is I reached out to the other side and said, "You have 48 hours to get back to me, or I am filing this petition to cancel." And I did a like draft petition that said this is not a trademark, and basically was very aggressive about it because the client got a notice saying your store will be shut down unless you deal with this. This was years ago, and so it's a little bit different now, but that happens a lot, and knowing how to deal with those folks is very important. And also knowing when they have established a brand, just because a phrase is something that is pleasing to see. There are some people who have established full brands based on phrases that might have one at some point been something that is widely used, or I think like the root beer brand, you're not your father's root beer or your grandpa's root beer or something like that. Like, they've established that now as a brand, and now I'm really dating myself because I think that came out like 10, 15 years ago. But there are situations like that where it is potentially something you can do, but it is not the purpose of trademark law to give any one company the ability to monopolize the phrase on the front of a T-shirt. That's just not how it's supposed to work, and you'll see people who work around that. And knowing how to respond to those folks is really important, I think.
Yeah, like they most likely to, they just want to be able to monopolize like that subject and not the predicate of the shirt, right? They want to be able to like lock down most likely to, and then be able to put I don't know, get elected president or something like that, or a class clown, or all they just want to monopolize every variation of that sentence going forward. And we've seen tons of that, the frivolous and overreaching
Right.
in terms of takedown. It's like it's been a plague for, I mean, better part of the decade that I've been in the game.
Yeah. No, and I think that it is common, and it is something, unfortunately, that is perpetuated by trademark attorneys who know how to work around the USPTO system, but are not thinking. I do both enforcement and I do registration, and I think that gives a lot of folks only do the registration portion of it, and then give it to their client and say do whatever you want with it. I think
Hmm.
that is a mistake because you end up in a situation where you have this registration, it's presumed to be valid, but then there's also the ability to cancel it. And I think that, and to hold people accountable for damages that they cause because of frivolous filings. And I think that is something a lot of folks just don't realize, that if they damage another company and are causing, and that they could be held accountable for that. And the issue is always going to be kind of very practical. Legal fees and time are always going to be weighed against the how much money are you losing? And that's one of these unfortunate facts, is that you always have to balance that. But um, knowing what the possibilities are important as well, because I think a lot of the times it looks like you're in trouble and that you did something wrong. And sometimes, honestly, you might be, and you got to be careful with that to know when you stepped over a line and that you could potentially could be causing issues with someone else's brand or copyrights. But then sometimes they're just, very something these people read something online, or are trying to do stuff that's anti-competitive, and I think that's the kind of stuff that people should be armed with what you could do to go against that, and that's canceling their trademarks. It's holding them accountable for damages, things like that. All right, final slide, and is if you're using AI-generated content right now, the Copyright Office and federal courts are saying that when generative AI creates an image, then it is taken from the thousands or hundreds of thousands of images that it was trained on. It is creating something technically new. There's exceptions to that, but that is not subject to copyright law. Copyright law must be made by a human, and that the output of a generative AI is not human made, so it is not subject to copyright law. What this means for you is that potentially, if you are using exclusively, out of the box AI created images and just putting them on designs, someone could take those and put it on their own designs and not actually be copying you because you didn't make it, an AI made it. And so there's things just, human expression is still a very important part of this process. And making sure to be careful with that of what you're doing. And the problem also is that people don't always know when something is AI created. And so it creates this thing of, well, could you be copying something that is actually protected? And so I wanted just to at least throw that out there to be very careful anytime you're working with AI. There's a number of lawsuits on the back end of everything that says, well, is it copyright infringement to train a model on someone else's images and their text and all that kind of stuff? And that's moving through the courts, and we'll see. We're nowhere near an answer to that, but just to be aware of that.
So I gotta ask you on that note, is there a defining line? It sounds like not yet, but if I had an element that was AI generated, but then I added my own words using, a design software like Adobe Illustrator or Photoshop or something. So I combined it with something that I created myself. Does that now make it copyrightable?
Right now, the case law would say no, that is not adding something that is not independently copyrightable is not enough to change it into something that is copyrightable. If you took an AI image and then painted it, that painting would then be subject to copyright law, which is kind of bizarre. But right now, the case law, it's called the Thaler cases, if ever, Thaler, that are kind of the at the top of that kind of case, you know, leading the way with that. And right now, the answer is that no, adding something small to it. If you add something significant, then that itself could potentially be protected separately, but the underlying work doesn't become yours.
So if I had a picture of a cat and then I put some words underneath it, a funny phrase, it's still not enough.
Under current case law, I would say not enough. Not right.
Okay.
But I also think that that's going to change. So I'm saying that's why I had one slide on it, because I do think that that's going to be something that's going to be really hashed out over the next few years, because there's some kind of, at the end of the line, everyone using Photoshop has been using a computer to help them make something look better for years. And at a certain point, when does it become AI versus just an algorithm? And so I think there's a lot of nuance to this that the Copyright Office was just like, nope, not going to deal with it. Not a chimpanzee taking a selfie of itself is not copyrightable because it's not human and no human. So I had a few more slides, but I think I am at a point where I want to kind of discuss with questions, especially I think one of them was getting into the political side of things. So happy to jump into that, or you grab some questions whenever people are ready.
Sure, yeah. For you guys that haven't, maybe solicited a lawyer or got hooked up with anybody, you can see Eric's contact information. I'll leave it in the description below after the chat as well, but it's eric@gerbenlawfirm.com, and you can get there also by going to, what is it, gerbenlaw.com. So, interesting fact about the AI too, because Photoshop now, like the classic design tools out there that have been around for decades, are now implementing elements of AI as well. So there's like, if I deleted a background scene of an
Right.
image in Photoshop, it can now regenerate. There's generative fill, so I can tell it what to populate the background with, and that's AI generated. Right?
And
So
Adobe has put their money where their mouth is with that, because they said that, I believe it's Adobe, and hopefully I'm not, but they said that that they will indemnify if something that they provide is copyright infringement because of something that they did with their model, then they will they will protect that. But they haven't said the other thing. If they haven't said that if you manage to invalidate your own copyright, then we'll protect you for that. So I think that's kind of the elephant in the room, is this idea of like, well, yeah, we're all pretty sure that what comes out of an AI model is not infringing because it's being created in a way that's not a copy. It is creating it from just an algorithm. And so, but the idea that what comes out of it would then be potentially, yeah, and so I actually include in my contracts now that says, when the client's working with a designer, they're hiring an artist, I put in there, it says, I did not use anything that would interrupt the ability for me to own or transfer the copyright of this, or saying something like that, just to make sure people know that if you're just sticking it in AI and saying, here, I made this for you, that's not something my client paid for, because they paid for original copyrightable work. So I'm not sure if it froze on my end or if that is Jay, but Jay, you're currently frozen, and I'm not sure if other folks are seeing that too. If not, I'm happy to monologue, but I'm not sure if I'm live or not. Jay, can you hear me?
Uh, I can now. Yeah, I lost connection there for a second,
Okay.
but I think we're good. I think we're good.
I wasn't sure if that was me or you, because I was like, "Oh, I can fill a void." That's one of my superpowers, is on a Zoom call just being able to talk nonstop. So, great. So, yeah, I think someone mentioned that. Catherine in the chat, that if someone stole your AI image, added text and it's nothing, yeah, I think that is the reality right now, is that the AI images that are coming out that are produced through DALL-E or Gemini or any of these other ones that are out there, that you know, there needs to be something that is the start of something you heavily manipulate in order for you to have exclusive rights in it. And you'd have to manipulate it to the point where it's barely unrecognizable from the original. The cynic in me says, who's going to know? And I think that's
Right.
something that people are going to push back on, but it's not going to become a problem until it is. And I think that's why I just have a pretty bright line rule. And even with our own firm, like, we're very kind of careful about when we're doing anything to do with AI that could affect the copyright that we own in it, because we have a bunch of people who steal our work, which is bizarre to me that IP attorneys would copy our work from our website, but we are very careful not to use AI for blogs and things like that. It's painstaking, but it's important.
Yeah. So yeah, follow up to that is Carlos saying, so even if the site like Kittle states that, so this is another design suite, or like it's an online platform for design that you can create designs that you can then use, I guess, to sell different print on demand products, for example. It says the Kittle states that you own the commercial license to the designs on their website, but the question is, you still don't own that AI image, even with changes, additions, subtractions to the design. So we're still at that. You have to manipulate it, even though the platform you design it on says you have exclusive rights.
Yeah. So I exclusive rights, meaning that they won't. So there's different ways to interpret that. I think that when you contract with them to create something, they have the right to put whatever limitations they want in place, even if it's not copyrightable. So meaning that what they are saying in that, at least the way I would interpret it without having a more information, is that they're saying that it is exclusive in that they will not resell it. And if they make you a design, it is exclusive to you. They will not provide it to others so that they can also use it. But that, yeah, you have
And then to
contracted with
say,
them. Yeah.
that you have commercial license, like they're saying that you own that commercially, you can sell it. They're just kind of absolving themselves.
I would, without knowing more, the idea that if they're using the word commercial license for something that is AI created, what are they licensing under current copyright law? Yeah, I would argue that you could still have contractual issues, because if they're showing you, hey, here's the thing you created, but you've agreed by signing up that you are not going to use this unless we say it's okay to. I think that's kind of the agreement that's entered into. But if someone else does find out that it's AI created and that they you copy that underlying AI, then under current regime, how it currently is, and I say that because I do expect it to change, is that that underlying thing that is created is not subject to copyright law.
Crazy. So like, yeah, they're saying, yeah, we'll give you, you can have free commercial license, you own it, but that's really not protectable, I guess, to at the end of the day currently.
Yeah, well, you can. I mean, you can certainly use it for whatever you want. So they're not wrong that
Yeah.
it is commercially available. And I think what they're also trying to say is that it's not something they've recycled. I think that's an important thing, and it is an exclusive right to use it on their behalf. So they won't let anyone use it, but they also, what they are leaving out with their, and I don't know, I don't have any other information other than, you know, very briefly, I'm looking at the website right now. I would be very, very hesitant to rely on that and to go after others based on images that were created using any kind of AI, with the
Yeah.
potential we talked about before. There's potential for pushback because there's, yeah,
Yeah.
you could be held accountable for a false takedown.
Yeah, and that's not Kittle exclusive. That transcends all design platforms, right? That's um, another question we had that was from Angela. It was just a question I have. If you're looking for something, a phrase using the word now common use, like Google, so it's like as a verb. Uh, are you allowed to use that as fair use? Is there a point where that becomes common phrase? Like when people say I'm going rollerblading, even though rollerblade is the brand name. Like I Googled, the question is like I Googled that and it's nasty or whatever. So like using the word as part of like your everyday phrase because that's what everybody just uses now. So is that fair use or is that still no go?
So it's got one of the greatest names of a concept in trademark law is called genericide. And when something has become the common name for something, it has become generic. It has died as a trademark. But as you can imagine, there's going to be a lot of nuance with that. Google, in particular, was held in 2009 or so, is the last time I saw this tested, is not a generic name. That is, it is just that they are the market leader, so that is why people are using it. But that is still a protectable trademark, and that one would potentially get you into trouble. But with trademarks in general, I think is this idea of, and we'll talk about this in the context of political folks, that it is about whether a consumer would be confused as to the source of that product. Would they think it was connected to the underlying brand owner in any way? Or are they endorsed by it? Are they associated with it? Did they make it? And I think that there's situations in which putting on the front, I Googled my name and it said whatever, or something like that. I think the risks are probably pretty low of that. No one would really think Google was making shirts that said that, but there's a risk involved anytime you use someone else's brand. There's some things like Murphy Bed used to be a trademark that is officially on the list of things that were, that underwent genericide. Carla said in the chat, Tupperware. Well, Tupperware will disagree with that. They'll say it is, plastic, whatever. But there's a few that have Escalator is one that is used to be a trademark, but no longer is. There's some that are on the brink, and I think those are the ones you have to be careful of. Band-Aid is one that is a brand name and still maintains the rights, but they will. Velcro is actually called hook and loop fastener, which I didn't know that until they did a very strange video about it for that exact reason. So be careful with those. If it's still a recognizable brand name where they are using the R with a circle around it, then that could potentially make people think that you're connected with them in certain circumstances. But it depends. Ring the bell again.
Yeah, I actually got a takedown many years ago for using the word Velcro. So it's like something
Now,
about
yes.
a kid sticking to the dad like Velcro or something like that. But yeah, it was. specifically that one. It's kind of funny, but great segue when you mentioned the political thing there, because a lot of us right now are, and I'm not including myself in that, but I was on the fence. I usually stay away from political stuff for mostly because it's so polarizing, and then you can't serve both audiences without kind of offending one or the other. But when it comes to print on demand and using the likeness or the names of people in running for politics, like right now we've got the Trump and then Kamala Harris, are we allowed to use it? Do we have to cease using people's names once they are no longer running? Because that was kind of like this unwritten rule that you can use anybody's names as long as they're a candidate, but once it's over, it's only the acting POTUS.
Yeah, yeah. So that is I think that is not something that I have heard of as a rule. It's not from a court case or anything like that. But where that comes from is this idea that there's a lot kind of that is baked into this idea of name, image, and likeness. It's become kind of the buzzword of, what if you don't own a trademark in your name? Trump does. He owns a whole brand. His entire net worth is basically branding rights is from what I remember seeing. He doesn't actually have much of anything other than a brand, and yeah, that's valued at whatever it's valued. And so he's got a much better argument that when people are producing Trump apparel or Trump whatever, that it could be actually confused with something he would make. But for the most part, when it comes to political candidates and famous people in general, it's if you're using it in a way that people would think that it is related to them or that they endorsed it or that they approved it or associated with it. And that's what I mean by related, and not just that it has their name on it, but that they would have approved it or licensed it. Then it's a issue of which is it, is that likely? And if you get a takedown notice, then you can kind of look at it on a case by case basis. But a lot of the times when it comes to political acts, there's so many people doing it that it's actually something that is protected under the First Amendment because it is when it comes to political candidates, criticism or support for political candidates is ingrained into this idea of America in general, and that is actually from court cases that say you're allowed to use. You're allowed to kind of do political speech, and that in that case, use of that is it would be arguably political speech. You just have to be extremely careful that because brands are still can be political campaign names. Most political candidates will register their names, they'll register their symbols, and if you are selling something that makes it look like it is official campaign gear, then that money is not going to the campaign. They don't have any control over it. Then that could become a trademark issue. Using photos, this is became really big for the Trump assassination attempt. There's a photo owned by, I believe, New York Times photographer, and that is one that is it, the photographer in the New York Times would have a great argument that no, you can't use my photo on the front of your T-shirt. I took it. I'm the copyright owner. You can't use it. And those are ones that I expect to see mass takedowns of those kind of things because everyone's going to do it and they're going to do it for kind of a cash grab. But that is a very kind of clear line of there's no reason to use that particular photo if you especially to sell products with that on the front of it. And so that's a very long-winded answer to kind of say that it really depends on how you're using it. And the further you can get away from anything that would be considered actual campaign gear and on their behalf, I actually, full disclosure, worked for the Obama campaign in 2008. I'm very familiar with the O that was made with the kind of like stylized O. And so that is something that it is registered as a trademark and continues to be used by, I think, the Obama Presidential Library or something, or the Obama Foundation. And so those kind of things are just something to be very careful of. I see a few. I think Tina asked about IP lawyers and wire transfers. I have only accepted a wire transfer when I'm dealing with a very large amount of money that the credit card fees would be too expensive. I think that I that would be a very suspect thing for a lawyer to say you owe me money through a wire transfer. But there are copyright. I will say copyright trolls. They partner with rights owners like photographers, and then they scour the internet looking for potential infringements, and then send
Wow.
a I've gotten several. One of them is called Higby and Associates. I'll call them out because what they're doing is bullshit. And but if you get a letter from them, they'll say, "Yep, you copied my client's work. You're not a licensee. You now owe us $1,000. Here's the portal that you can pay through." And it's all very, systematic, and it's just like makes me like just my stomach turn a little bit because of how just gross it is. But that
Yeah.
is a scheme. So I could see, Tina, that potentially being a part of one of those schemes where they say, "Yep, you used it without permission, pay up, and here's how to pay it." But I think that I would never do that.
Nice. And Kristen says, I just got 12 listings taken down for Boy Mom. Boy Mom owner has been on a rampage for years now, for a few years anyway. I put Boy Mom on a sweatshirt and had Boy Mom in tags, not knowing I couldn't target Boy Moms. Where does the line get drawn?
Yeah, that is one that I do not know. I think I may have even mentioned this earlier, but that's one that I know as a phrase. I am not aware of any brand that has actually been created if I saw, I will say my personal opinion, not legal advice, is that if I saw that on the front of a t-shirt, I would not associate that with any one brand. I would associate that with people who are mother of boys, that concept of being a boy mom. I and that is from my kind of limited information that I've got. I think those would be very difficult for someone to enforce if someone were to say file a petition to cancel their trademarks and on the grounds that it fails to function.
Yeah, I think there's a few people I was talking to in another Facebook group. It's basically built around fighting frivolous trademarks, and I think I think there's something there about people wanting to cancel this because it's been out of control, I think, for a while. But that's a testament to people overreaching
Right.
sometimes too, right? Like
Well,
you're
and
putting your
yeah, fear, misinformation, a lot of stuff that goes into just what it would take to take on something like that. And sometimes it is you go hard just to say, withdraw your thing, I'll take down the thing. I just don't want a strike on my account. And I hate that that's kind of the common approach to it. But do I want to spend, if I'm a trademark owner, tens of thousands of dollars at least to try to cancel that? What do I want at the end of it? And if it's a crusade, I will be prepared to spend probably $100,000 if they fought it all the way to the end of trial. But there's a lot at stake. So I think that sometimes it's a good approach to use just to kind of push the needle towards them leaving you alone. And I'm always a kind of a pragmatist when it comes to that kind of thing.
Yeah, I mean, it has to make sense financially, right? And never mind how long you could be litigating for, I think, too, is a big one.
Right.
Rhonda says, how do you know if you need to use a circle R when naming your product brand in description of your listings? For instance, Comfort Colors shirts, Bell and Canvas shirts, etc. So I know TM was for trademark pending, and R is officially registered, is my understanding. When you're using another person's brand, for example, is it necessary to use it?
Yeah, that's a good question. I think so. We're getting into this idea of when can you use other people's trademarks, and that's going to be another thing that's very platform by platform. When you're saying something like Comfort Colors, if you know they have a registered trademark, it doesn't hurt to put that. Otherwise, you can always use TM. If you are referencing someone else's brand and you want to make it clear that you're not using it kind of descriptively or generically, you can stick the superscript TM in the end of anything, even your own stuff. If you're claiming it as a trademark and you're not sure if it's registered or not, then the safe thing is to use the TM. But it's not ever necessary to use a trademark symbol unless you're a licensee. If you have actually entered into a license with someone, it probably says in your license, I will use X or X, Y, and Z when I use it. But if you're just describing something that you saying, yeah, this is going to be printed on this kind of Gildan T-shirt, then using the TM is fine, or not using it at all. There's no kind of rules with that.
Yeah, I think that one specifically, Comfort Colors, Rhonda, if you look on, I think it's Printify's website, they have, because they've also added not just the Comfort Colors and the Bell and Canvas, but they've added Adidas to their catalog now.
Hmm.
They have specific rules for using the brand names of shirts. So you are allowed to use it, but I believe you have to have the R in the circle
Yeah,
to use Comfort
that's a
Colors and Adidas. But,
that's a really
you
good
know,
point. Yeah, check the website because they might have usage requirements that I mean, you didn't enter into a contract with them, so they might just reach out to you and say, "Hey, here's how I'd like you to use it." But sometimes, if you are purchasing from someone, anytime you have a contract, law goes out the window, and you focus on. Oh, yeah, there we go. Printify has a license with Adidas, so yeah, that's actually a great example of where I'm completely. Thank you for clarifying that. That if there's a contract in place, a license in place, absolutely pay attention to that all the time. Some brands have usage guidelines that they put on their website that of how they like you to use it, and so pay attention to those just to be kind of nice about it. But yeah, if it's a contract, you are required to do it.
this question is a bit more on the SEO, and I heard that if you have boy mom separated anywhere in the titles and tags, Etsy can put it together. It counts if you show in search results. So yeah, Etsy will broad match keywords, so you can show up for boy mom. So if the boy mom owner, for example, was to search boy mom on Etsy and you show up, I would, knowing how she's been defending her trademark or going after people, I would probably steer clear of doing that unless you can, maybe prepared to get a lawyer to help you out because she will probably take you down. She's been pretty kind of casting a wide net that way. Um,
And in the same aspect that in general, a space, if you did have like, and this is not, I don't think the question that you were asking, but boy space mom is legally equivalent to boy mom as one word. The space would not be something that, if it were a valid trademark, that would not change the ability of the brand owner to enforce it.
okay, good to know. Because people have tried to actually break the word into two, putting a space and to say that they're circumventing something, but not the case. Carla is asking about song titles. This is a good one. We hear this all. We see it all the time too, especially with like the Taylor Swift lyrics and stuff. People are just putting that on shirts, right? So, are they not protected by copyright, or do
Oh,
titles mentioned in Circular One not apply to songs?
that's a really good. So the ring the bell again. It depends on how much of it you're using. There's this idea though that yeah, likelihood of confusion would by using this make people think that you were allowed to do it, that you were licensed by Taylor Swift. She's got a number of her song lyrics protected because she has made those into their separate brands. I think in a similar way to actually make it clear that it is a brand of these, her album titles, things like that. That is all things that if it relates back to them, that they could be protectable. They're not on their face trademarks. They are song titles. There's millions of song titles in the world, but when it starts to relate back to a specific artist that you are attempting to mention, that's when it can get into this idea of, well, are consumers likely to be confused by this? In general, it would be trademark law. Copyright law does not protect short words and phrases, but if you're doing a whole line, at what point does it stop becoming a short phrase? And I think that's where there's no clear, yeah, did you protection for copying a yeah, full line of a Taylor Swift song that's noticeably a Taylor Swift song that could become a problem.
And now, does that change when you're talking the title of a song?
Same thing. And
Same
if
thing.
it does, yeah, relates back to the original artist, and that's the point is to relate back to that original artist, then that generally can start to raise the risk. I think there's always going to be defenses that you didn't use enough of it for people to be confused, or it was so heavily branded with everything else that's yours. That's why I kind of mentioned at the top, creating a strong brand that you own, that you can partner with things like that might make the risk lower.
And then to clarify, Carlos saying, for example, if you use the phrase that is also the song title, uh, if it's unrelated to your product, you should be safe.
Yeah, I mean, I think that if you are not, that would be a great defense. That if you are using a phrase that happens to also be a song title, and there's not that distinctiveness where people would realize, like, oh, I'm buying this to because I support Taylor Swift or something like that, then I think it's going to be a lot, because every word and phrase is probably a song title of some kind. I'm a musician. I've got yeah, there are millions of song titles. So I think that would be the question, is whether consumers would relate it to a specific artist. And if so, that's not the end of the inquiry. I think that there's still ways to potentially do it, but it just becomes more risky.
And then Tina goes back to the schemes that we were talking about earlier. Are they legal? Well, scheme in its own right, almost by definition, is like something that
Well,
is
there's
illegal.
yeah, there's legal scheme, and the thing is that what they're doing is not incorrect when it comes to the basics of copyright law. There is a photo on the internet. You took it, and this is my client dealt with this. They took it and they put it on a location page on their website. They did not pay for that, and the photographer said, "You didn't pay for that," and you are now a copyright infringer. That is legally correct. That there's nothing that is incorrect about that statement. You copied something you weren't supposed to. You have infringed. But then the ask is really what gets you, because they're going to ask for $1,000 or $1,500. If you would have licensed that image, it probably would have cost you about $2 because you got it from Shutterstock, or maybe even if you were getting commercial rights, it might be $50, something like that. Is that commensurate with what they're asking? And a lot of the times, it's nowhere near it. They're saying just an arbitrary amount that if they were to sue in court, the judge would be like, for a single use of this phrase or of this infringing image, you're not going to get $20,000. Here's $2. Go away. Yeah, and so, but they bank on the idea that people aren't going to fight it. They're going to be so scared, or if they do have to sue, that they're not going to get a response and they can ask for whatever they want. And so that's why I call it a scheme, because it is really based on this idea that people don't have the time or money to fight it. And every time I've ever gone back to them, they've reduced the amount to the point where I had to tell the client, it will cost you more for me to continue arguing with them to just pay them. And it's injustice. And I say, if you want to really stick it to these guys, I'd be happy to. Then it will cost you $20,000. And so I think that's where I call it a scheme, because it's not it's not technically incorrect. It is just slimy and
Hmm.
abuses copyright law in a way that I think copyright law unfortunately allows for right now, in a way that I just think is morally reprehensible, but not necessarily wrong. So I think that's where that kind of sits.
We're coming up on just over an hour here, and I think it'd be a good one to wrap up here. We've got two more questions here. The main one is how much are fees? This is good information, right? Like how much are fees, and how much would it potentially cost to get a lawyer to defend or fight an IP case? I think that's a massive depends as well, right?
Yeah,
Just
so I'll kind of give you my general framework for things. So trademark registrations, proactive things, copyright registrations, depending on what you need as far as risk assessment, things like that, anywhere from kind of per item, starting around $800 up to about $1,500, and then government fees on top of that, is kind of to register something ahead of time and to get a risk assessment. Our flat fee is $1,500, but that's not what we're talking about. But so that is kind of, flat fees are in that range. There's much cheaper ones that are available. I think you get what you pay for. Law firms often will charge, like large firms will charge $5,000-$6,000 for a trademark registration. I find it nuts. The other one is, what does it take to defend something like that? I think that typically, if everyone is being reasonable, and we can come to something that says, you will withdraw your complaint, I will not sell this design anymore. Let's say that's something I've done before. The last time I did it took about $2,000 or $3,000, because I have to go back and forth with the other side, and then we've got to draft an agreement that everyone agrees to. And so I think that is where it starts. It obviously can escalate heavily. I've been involved in litigation that costs, I think, we're about $150,000, but most of the time, $3,000 to $5,000 is what I tell clients to see if we really to see where we are as far as kind of getting things done. If everything goes very smoothly, we can maybe even get it done even quicker than that. But I think that that's typically where my costs are, and then you can kind of there's going to be, I think, in the bell curve of things, we're probably somewhere in the middle, but there's going to be different people in different spots.
nice. Good information. Somebody is asking if you use your own source image, and we actually, I think, address this. If you use your own source image, say a picture you took, and then asked AI to create a similar image, is that copyrightable? The answer so
No,
far is no, right?
no. Yeah, unfortunately not.
And then Carlos asking, could you explain international IP laws? That's kind of like a super
It was
broad.
explained to me that international IP laws are not they're not a thing. It is a country by country thing. The only exception to that's the EU. There is something called the Berne Convention, which almost every country in the world is a part of, that says we will recognize each other's copyrights, so that you don't have one person owning the copyright in the US, another person in Canada, another person in Mexico. That is not the case with trademarks. You can have one person own it in the US, one person in Canada, one person in Mexico, one person in the EU, all using the same name for the same product, and it's completely territorial. So the EU is the only one that has a block where you can register for the entire EU that now no longer includes the UK. So trademarks are really a minefield when it comes to international protection. And then copyrights, there's some countries that just don't, they'll recognize your copyright, but they don't have laws to really enforce them. And so it's like, great, you own it, but like, what are you going to do in certain countries? So I think that is something to be very careful about, because depending on where you're selling, you could have a completely different set of things that you're having to deal with from a brand perspective.
Nice. And then, yeah, it's kind of funny because there's so many different databases to check for all of this stuff too,
Right.
and it's kind of hard to, you know, um, I can share with you, Carla, some resources that I have based on the Amazon merch website. They gave us a list of the copyright databases for, I think, at least five or six, the five continents anyway. Um,
Yeah, there's one called the Madrid Protocol. I forget, it's the WIPO website that actually I can try to find that and send it out. That they've got a pretty decent database of a bunch of different countries, but it gets a little. It is only as good as the data, but it is a kind of like international organization that's pretty trusted.
okay, good to know. And then the last question for today, I think, is how do you handle it when some big corporation steals your designs? I guess it
You
comes up to
sue
how
them
much
into
money.
oblivion. No, yeah, I think that's the when a big that comes down to a lot of issues of, is it copyrightable? Because if it's not, then they stole your designs, but there's not really anything to protect with that. Did they steal your trademarks? If not, what do you where do the damages come from? Um, Registering your copyrights gives you access to more damages. So if it right now, yeah, that is something just to be aware of, that you could win a case, but what would it have cost them for them to license it from you might be the damages. So that might be, a couple $1,000s, might be more. So I think it really does depend on how egregious it was, how many copies they made, how much profit they made, and what you proactively did to protect the designs.
Yeah, and how much skin you have in the game, right? Is it
Right.
worth your while and time and money spent? At the end of the day, are you going to be in the black, or are you going to dig yourself this deep financial hole, right? I
Hmm.
mean, I think you got to be, pragmatic about it. This has been amazing, Eric. Thank you so much for doing this. Well, again, folks, we're going to link to Eric's email address and website and everything down below. Um, any any questions you guys have, drop them, and maybe we'll get Eric on again one time, sometime in the future. Thanks so much for doing this, Eric. It's been, you're just a wealth of information. So
Yeah, absolutely, Jay. Thanks for having me on.
my pleasure. All right, folks. Yeah, let us know. Please share this video. It's a ton of information that I think is super relevant. We talked about politics. We talked about the whole Taylor Swift thing. This is stuff that everybody needs to know. So thanks so much again. And we'll see you guys in the next one. I'm just going to stop the share now.